The average American dies with $62,000 in debt. That's according to debt.org. But what happens to that debt? This is a question that is often misunderstood. The debt does not become the debt of the heirs or beneficiaries of the borrower, of the person who passed away. Unless, of course, they are otherwise obligated on that debt. For example, if they're a co-borrower, a co-signer, a guarantor, or perhaps it's a joint account like a joint credit card account, in which case the survivor, the co-borrower, would remain responsible even given the death of their co-borrower. Going back to just individually held debt by the person who passed away, if there's no reason for a probate, now see my other videos on reasons for probate, but usually there's not a reason for a probate if there are not assets that need to be probated. If there's not a probate, then there's no vehicle for creditors to pursue collection of the debt that was owed by the deceased person at the time of their death. Now, if there is a probate, there are specific requirements and restrictions for creditors. And if they fail to follow those requirements, their entire debt could be extinguished. That means totally wiped out and not a responsibility of the estate. If there's an estate, a probate, and if the creditor follows all the required legal and statutory rules for collecting their debt from the estate, the debt is usually paid from, well, it's paid from the estate assets, but usually after repayment or payment of funeral expenses, attorney fees, personal representative fees, and things of that nature. Depending on the nature of the debt and the priority given to that debt for payment out of estate assets, oftentimes the debt does not get repaid. Now, what's important to understand, and we get this a lot, is the debt of the person who passed away does not become the personal debt of the obligation for the personal representative or for any of the heirs or beneficiaries individually. Now, it might impact them because it may be paid out of estate assets that were supposed to go to them, but it does not become the heirs or the beneficiaries or the personal representatives' personal liability for the person's debts. We get asked that a lot of times when people are setting up their estate plan. So if I leave this to somebody, does that mean they also get all my debts? Well, in a weird way, maybe, because it's got to be paid from the assets that you're leaving to them, possibly, based on what I talked about earlier. But it does not become their personal obligation to repay debts. If you have any other questions on estates, probates, estate planning, drop them in the comments. We're happy to shoot another video and answer your questions. Keith Taylor Law Group, be sure to like and share our video. Hope this helps you.